You ever wonder if a court can just look at a case and say, nope, not hearing it? Well, they can. And today, we're going to look at two really old, really powerful legal rules that are basically the court's ultimate stop signs. Let's get into it. To really get a feel for how this works, let's imagine two totally different, kind of strange situations. They might sound a little absurd, but trust me, they perfectly show why our legal system has these stop signs built right in. Okay, first up, picture this. You and a buddy decide to rob a bank. But during the getaway, your partner drives like a maniac, crashes the car, and you get hurt. So here's the question. Can you actually sue them for negligence? It sounds completely wild, right? But it's a fascinating legal puzzle. Now for something a bit more down to earth. A friend promises to give you $100 for your birthday. Great. But then they change their mind. It's annoying for sure, but can you actually drag them to court and make them pay up? Well, the answers to both of these questions are hidden in two ancient principles. So let's tackle that bank robbery first. The legal system's answer to this whole mess comes from a rule with a super dramatic name, the dishonorable cause principle. And here it is, in all its Latin glory. I know, it looks a little intimidating, but don't worry. What it actually means is incredibly simple. And there you have it. No action arises from a dishonorable cause. That is a really powerful statement, and it's a bedrock of our justice system. But what does it actually mean in practice? Okay, so here's the bottom line. The law is not going to help you if your complaint is tangled up with your own illegal actions. The court basically throws its hands up and says, look, you are in the middle of robbing a bank. We're not getting involved in this. This is all about protecting the court's integrity and making it crystal clear that a courtroom isn't the place to sort out criminal disputes. All right, let's pivot to our second puzzle. That broken promise about the $100 gift. The answer here comes from a totally different but just as important principle. And yep, we're starting with the Latin again. This one might sound a little less intense, but believe me, it's fundamental to how we think about contracts and agreements every single day. The translation here is really straightforward. No action arises from a bare promise. Now that key word is bare. What in the world makes a promise bare, or, naked in the eyes of the law? This is all about the idea of a two-way street. You see, for a promise to become a legally binding contract, there has to be a real exchange of value. Each side has to give something to get something. The fancy legal term for this is consideration. A simple gift where nothing is expected in return is just a one-way street. That's a bare promise. And without that two-way exchange, it's legally empty. And this example makes it super clear. Instead of just a gift, imagine person A says, I'll give you my car. And person B says, great, I'll give you $100 for it. See? Now we have that two-way exchange. Both sides are giving something and getting something. That exchange, that consideration, is the magic ingredient that turns a simple, bare promise into a real contract that a court can enforce. So in both of our stories, the court says, nope, not hearing it. But, and this is the important part, they say no for totally different reasons. One case is all about doing something illegal, and the other is about a promise that's just empty. Let's put them side by side to really see what's going on. This slide really lays it all out. On the left, with Turpi Causa, the court is focused on the nature of what you were doing. It's asking, was this person doing something illegal or immoral? If the answer is yes, then game over, the court won't touch it. But on the right, Nudo Pacto is different. It's all about the structure of the deal. The court's asking, was there a fair two-way exchange here? If not, then the promise is empty and the court won't enforce it. And here's where it all clicks into place. For our bank robber, the case is thrown out because it came from a dishonorable cause, the robbery itself. For the broken gift promise, the case is thrown out because it was based on a bare promise, with no exchange, no consideration. Two very different legal paths, but they both lead to the same destination. The courthouse doors are closed. So you might be wondering, why have we kept these ancient Latin rules around for literally centuries? Well, it's because they serve a really deep purpose that's just as important today as it was back in ancient Rome. So even though one rule deals with high-stakes crime and the other with a simple broken promise, these two principles are actually teammates. They're both working together towards one single vital goal. And that goal is all about guarding the integrity of the justice system itself. Think of these rules as gatekeepers. They make sure the courts aren't accidentally used to help criminals benefit from their crimes, and they stop the system from getting clogged up with every casual promise that someone breaks. At the end of the day, it's all about fairness and making sure people can trust the law. And all of this leaves us with one last really fascinating question. The rule about a bare promise is pretty black and white. Either there was an exchange or there wasn't. But that idea of a dishonorable cause, well, that's a lot fuzzier. So, as our society's ideas about right and wrong are constantly changing, how do modern courts decide what's too immoral or dishonorable to even get a hearing? Where do they draw that line today? It's a tough one, and it's definitely something we're thinking about.